Hi, this is Ty Hadarali. I'm a plaintiff's lawyer. We concentrate in employment law in New York and New Jersey. So I want to talk to you about the fascinating topic of claim preclusion and collateral estoppel. What's that? Well, it has to do with, it's actually a very important topic for plaintiffs that has to do with the issue of if you're going to sue your employer, where do you sue? And what are the impacts of suing in one form as opposed to another? So in the case of Simmons versus Trans Express, Simmons basically filed a claim in small claims court for a wage and hour dispute, claiming unpaid overtime. And even though the amount that Simmons claimed was fairly significant, the jurisdictional limit in small claims court is $5,000. The court heard the matter presented by Simmons in small claims court, and Simmons was unrepresented, and decided to award Simmons the amount of $1,000. Subsequently, Simmons filed an action in the Eastern District of New York under the state and federal wage statutes, this time represented by counsel. And the issue then came up, well, wait a second, what impact, if any, does the Small Claims Act action have on Simmons' ability to pursue the company in federal court? And there were two competing issues the court had to deal with. One was a New York Civil Act, Section 1808, that had to deal with the issue of collateral estoppel, issue preclusion, and really seemed to be inconsistent with some of the case law surrounding this issue. And in essence, the court dealt with this issue of claim preclusion, issue preclusion, and said, it took a nod towards the very stark reality that, when people litigate in small claims, they don't take the matter maybe as seriously as they would in a more robust forum like state court or federal court, and found that because of this, you have to really look carefully before you declare that the plaintiff cannot proceed in another forum, and looked at certain issues such as what are the issues that are being litigated? What are the potential recoveries that can occur in the forum that was initially that the party initially litigated in? And the court, in essence, found that under an 1808 analysis in New York, that a small claims action in this case did not preclude Simmons from pursuing the employer in state and federal court. So really, at the end of the day, the thing that employees, that parties have to be cognizant of is be really careful where you file your claim. Because even though for Simmons everything worked out okay, it may not be for the next plaintiff, because it's a very fact-specific inquiry that the court will look at that may result in you not being able to litigate your claim in federal court or state court. This is Ty Hadarali. Be safe and be well.